Scott Talley coming to you from the worldwide headquarters of Network in Action. Today we're grateful to have attorney Darryl Scott with us from the Darryl E. Scott Law Firm. Darryl, welcome.
Thank you for having me.
Glad you're here. Darryl has a specialty in law that we're going to talk about today. So tell me a little bit about the law firm.
Sure.
And what you specialize in.
Sure. We're a full-service intellectual property law firm. We deal with patents, copyrights, and trademarks.
So what he's saying, he's a really smart guy and he can help you, right?
Exactly.
So obviously, this is a really important arena for businesses. So talk to the business owners about, let's just start with trademark.
Okay.
And let's talk about some of the mistakes people make and some of the things you've seen in your career, where if they had gotten hold of you a little bit earlier, they may have saved themselves some grief.
Of course. What I could do is probably give you a scenario that occurred, not particularly with my client, but with one of my client's colleagues. So there was this firm in California. They were a bike shop, a small mom and pop shop. They were in business probably about 10, 15 years or so. But unfortunately, they never trademarked their brand. So what happened was a bigger organization came behind them and said, hey, you need to cease and desist using your brand. You did not register. You did not have federal protection for your trademark, so you will need to stop. And the unfortunate thing is that that company did not have enough accreditation in order to keep the brand, so they had to rebrand their business. But in the process of rebranding, they filed for bankruptcy and they lost their business. So it's very important that any company at the infancy stage of their business do an analysis of whether or not the brand they're using is even worth it.
And give us a range, because in that case, they lost their business. But let's say they'd have been able to save their business. Mm-hmm. They still would have had to gone out and recreate new goodwill, new signage, new business cards,
Exactly.
New website, new URL. I mean, they're basically starting over in a lot of ways.
Exactly.
Which would have been expensive in and of itself. Mm-hmm. But we're not talking about a terrifically expensive process, right? Like, give me a range of what it costs to trademark.
Sure. So if you had to deal with me, the range for actually performing a trademark with the USPTO can range anywhere from $225 to $400. That's just to register a trademark. Now, of course, there are some prerequisite steps that need to be taken before you register.
You've got to do some research and make sure the name's not taking those kind of things. So they might spend a couple $1,000 to get this done? Or?
Yes, that is correct. And I always tell my clients that it's always cheaper to talk to an attorney on the front end side than it is to be saved by an attorney on the back end side.
Pay me less now or pay me more later. That's what I always say. It's true. It's so true. It's
exactly.
So if you're a business owner and you're getting started, no matter what your goals are, I mean, if you have a cottage business, you really ought to take the time to, I always tell people, once you find out if you can get the URL you want for your company, the next thing you need to do is trademark.
And even before you get the URL, you still need to search. Yeah. Because I've had a client who actually purchased a lot of domains that had the same similar name as someone else who had a registered trademark. Mm-hmm. They had to give up all their domains and give it over to that client.
Oh my gosh. So once you get that trademark, which takes 2 or 3 months? Or?
Well, unfortunately, it may take anywhere from 6 months to a year.
Okay.
Now, one of the beautiful things is that if you do the research before you try to register the trademark, you can actually start using your trademark. Okay. You can insert the symbol SM as for a service mark, or you can insert the symbol TM for trademark. You may see it in our advertisement where you see TM as a kind of a small little note in the right-hand corner of your logo. Mm-hmm. If you're doing that, you're actually placing people on notice that, hey, I'm using this as my common law trademark, which gives you some type of protection, but it does not give you federal protection. So there's ways you can protect yourself while you're trying to protect yourself.
And so I put in the process, I've gotten my trademark, I'm using it properly. I've got some responsibilities to protect that trademark. Talk about that a little bit.
Yes. So once you have your trademark, one of the things that you want to do is, of course, you want to build your business and your practice, but at the same time, you want to make sure that others are not using your mark. Because what happens is that if someone else is using your mark and you're not sending them a cease and demand letter to discontinue using the mark, you run across the likelihood of someone damaging your goodwill, because someone could be using your mark inadvertently, could be causing damage to the market, and that can play onto your brand. So one of the things you want to do is keep others from using your mark, so you can keep your goodwill intact with your clients.
Am I right that that the obligation falls on me? So even if they didn't hurt my brand, the fact that they're using something similar, can I lose my trademark?
No. You can't lose it. The only way you can lose it is if you don't re-register.
Okay.
And you can re-register every 10 years.
Okay.
Outside of that, it is it is the burden of the owner of the trademark to tell others not to use it. So the only protection you get as a registered owner is the right to keep others from using it. It doesn't necessarily give you the right to use it, but it allows you the right to exclude others from using it.
Gotcha. So that's something you definitely want to look at if you're a business owner. Get started on that process as early as you can.
Exactly.
What other protections should a business owner look for?
So outside of just trademark, any type of art, any type of commercials, any type of advertisement, you can also look for copyright protection, which is somewhat similar to trademark, except that you have a particular art that's been reduced to a medium, meaning like some type of book or some type of platform or anything that we classify as art. So that's an area in which I tell some of my clients, especially business owners, that they need to be looking for. Now, the other aspect, which is more of a minority in some instances, depending on what type of business you have, I also direct them to look at some patentability areas that they may have within their company. So, for example,
I was saying, before we get into that, so let me ask about the copyright. So,
Sure.
if I'm producing a lot of videos for YouTube and things, blogs and literature, how do I copyright each one of those?
So specifically with YouTube, there's some challenges with that because by you uploading your videos on YouTube, you may be giving up some copyright rights to it because there's that long checkbox. You have to read that long literature that they give you saying that read this before you hit the checkbox, which most of us don't read. Right. In some cases, you're actually giving up a lot of your copyright.
And you must be just an incredibly exciting time. I mean, really, you think about historically, maybe your industry, somebody might think it's sort of boring or what you do, but nowadays with all the different media and all the different mistakes people, all the places people can produce content, it's got to be really a bunch of changes since you left law school.
It has, but the unfortunate thing is that although there's been many changes, the mentality has not changed. I find myself coming across clients who don't have the appreciation on how important their intellectual property is. So what I tell them is think of your intellectual property as your personal property. You don't want no one running into your house unprotected. You don't want anybody in your yard unprotected. So it has the same type of need and requirements as your intellectual property. Both can be taken from you. And if you're doing everything you can to keep someone from taking your personal property, you should be doing the same thing for your intellectual property.
So if I'm not copywriting every video I put out on YouTube, give me what kind of things would I copyright? My manuals, my training materials, things that are proprietary to us. And what's that process look like? Do I send those to you and then you send them? How's that look?
So it's a very simple process. Copyright is actually the most easiest process and it's the most inexpensive process. And the reason why is because each change you make in your literature or art, you have to re-register it. Okay. So copyright only protects what is actually being created at that moment. So the process is that you would come to me, we'll talk about your copyright, and we just basically register it. So, but here's the thing. Once a person creates an art, it's already by law copyrighted. The only difference between it being registered and unregistered is how much you can get in restitution if someone infringes on you. So like if you wrote a book, you never copyrighted, and someone else was using your book, you can sue, but the amount of damages you receive is a lot less if you had not registered in the first place. Now, you do have some recourse in that. If you find out that someone is infringing on your book, you have exactly 30 days to register your copyright, and then you can get close to, but not up to, everything that you could have received.
So, again, let's stick with the process. So, you're my attorney. I've got a number of items I'm going to copyright. I'm going to send them to you. Ballpark, give me a range of what it's going to run. And do most of your clients send you multiple things over every few months, or how's that work?
So dealing with the first part, so the price. The USPTO charges anywhere from, not the USPTO, the copyright organization, copyright.gov. They charge anywhere from $35 to $115, depending on the type of art that you're uploading. Most of them will fall within that lower range.
And is it also text, or is it primarily art?
No, it could be text. Okay. So it could be a journal article, it can be a novel, it could be a book, it could be anything.
Training manual.
Exactly, exactly. It can be a video, it can be just art, or it can even be the pictures that you see online that people snatch off and use for their own personal use. Yeah. So I tell people not to just snatch photos off a website because it can be copyrighted. Yeah. And they can come after you for doing that.
Yeah. We had that. I was in the publishing business years ago. We had that with I think it was Guggenheim or somebody, some museum, and they started sending us letters, coming after us. And,
Yes.
okay, cool. So other protections. You were getting into another area. It's a little more serious.
Yes, and that is the patent protection. So a lot of times people feel that they don't have a patentable invention. One is because it's a very difficult process. It's actually the most difficult amongst the other two or amongst the three. And what I tell my clients is that anytime that you solve a problem that no one else was able to solve, you may have an invention. So that can be anywhere from a process to something mechanical to something chemical to any combination thereof.
Software?
Software, yes, to a certain extent. Now, software is a little challenging right now because the way the cases are falling, the rules are changing, but the way they stand right now, if the software is not associated with something that's tangible, meaning it's not attached to a car engine or something that's mechanical in nature, then they would consider that being abstract. And anything that's abstract, you cannot patent. But the courts are kind of moving away from that, but it's going to be some time before we get there.
Well, how much time do you spend reading a week to keep up with stuff? Because you got a really interesting changing field.
So I read every day, unfortunately. I spend a couple of hours reading, look at the latest law that comes in. I'm actually receive alerts from Westlaw, or LexisNexis, which is the database that keeps all cases. So I try to keep up to date on what's the latest law. And then more importantly, just the process in and of itself, because you have the law, then you have the process, and then of course you have the application. So it's many different areas.
So in your firm, you're working primarily by yourself?
Yes. As far as so in my firm, yes, I'm a solo individual. However, I've associated myself, or what we like to call of counsel. So I'm of counsel of a bigger firm, where if they need an expert on a case, specifically as it relates to intellectual property law, then they bring me in.
Yeah.
But for the most part, yes, I'm solo.
So I know the advantages to you of being solo, but there's advantages to the consumer too. Talk about the business owner that's going to go out and look for an attorney, and the advantages of working with a guy like Darryl Scott.
So the advantage that you'll receive with me is that I'm not particularly looking to work with a big organization. Because most patent attorneys, and just to kind of give you a little background, a patent attorney first has to have either a technical science or engineering background and or have a degree in it. Then they have to go to law school. They have to take the bar, and then they have to take a subsequent bar, which is very challenging. It's, my opinion, is much more difficult than the actual bar exam. So it's 2 bars. You have to have an engineering degree or science degree. So it's a lot that's built into becoming a patent attorney. So when you have that level of pedigree, you want to go after the big fish.
Sure.
Me personally, I don't. I have no desire to go after the big fish because there are a lot of people who are just as innovative, inventive, who do well in their art, who are not a part of the big organization. Yeah. So with me particularly, one, you're going to speak to me. You're not going to speak to an associate. You're not going to speak to a secretary. You're going to speak to me. You're going to have my personal cell. You're going to have my personal email. I don't have particular hours where you can only contact me between 9 to 5. You can contact me on the weekends. We can chat whenever, because I understand that this is your baby and you want to protect your baby. And your baby don't cry just 9 to 5.
That's right. And I can tell you, as a business owner for the last 30 years, there's nothing like being able to reach an attorney when you want to talk to them and deal with them. So I can see where that's an enormous benefit. And you obviously have the same resources with LexisNexis and those things that the big law firms.
Yes. So I've actually done work for bigger organizations, bigger firms. So you'll get the big firm experience, but focused on the little man.
Yeah, that's awesome. What other, tell us a horror story when it comes to patents, maybe about a client that you've heard about or some company. People love horror stories.
So let me see if I can think of a horror story. The horror story was the original one with the trademark. That was a horror story. I mean, I have horror stories in other areas of the law, but let me see if I can speak to
patents. About around patents?
Well, the only horror story that I can give, and it's kind of it's used in almost in every aspect. So one of the horror stories that I've had experience with or exposure with is missing a deadline. Because here's the critical thing with patents versus any other area of the law. Deadlines are critical, meaning that if I miss it, if you miss it, you're done. Mm-hmm. So once you publicly disclose your patent, whether it be to me without a non-disclosure agreement or to any other person, or once you file it, the clock starts. If I miss a deadline, you can't do it again. It's over and done.
Wow.
So amongst lawyers, and they'll probably understand this joke, is that patent prosecution is like federal rules of civil procedure on steroids. It's crazy. And the thing is that it has national ramifications. So if I mess up in the USA, I can't get any patent protection in China. Wow. I can't get any patent protection in Indonesia. It's done. Unless you make some amendments to it or some modifications that are, again, novel and inventive, then you may be able to have some recourse. But if you it's like the prosecution. You only get one chance, one bite at the apple. And if you don't, you're done.
What's the time frame for a typical patent nowadays?
It can range anywhere from a year and a half to, I've actually had patents that run 9 years.
Wow.
And that's usually at the higher level. And that's when you've appealed several times, you've reopened prosecution, and you just kept trying. But here's the thing, is that the person only has patent protection for 20 years from the filing date. So if your filing date is, let's say today, and we get a patent 2 years from now, you only have 18 years to exclude others from using it. Wow. But if you're in prosecution for 9 years, then you only have 11 years.
A bunch of money invested. That'd be a good patent.
Exactly.
So in this, talk just for a second, like the type of things that you want to get a patent on, in the term patent pending. Yes. You know, I hear that a lot on Shark Tank. They'll always say, "Yeah, patent on this." You know, got patent pending.
They're lying.
That's good.
So whenever they say they're patent pending, they don't have a patent. What happens is that someone filed a patent application and they received a filing receipt, which is usually within 2 weeks. Okay. Now, you also receive what they call a notice of publication, which is anywhere from 6 months to 10 months. And what that does, it actually places your patent in the public sphere. Mm-hmm. So everyone can actually research it to see exactly what you're patenting. Now, during that time, I can't exclude anyone from using it. Now the USPTO could keep others from getting a patent on it because it's been already publicly disclosed. But during that time, that's when prosecution is going on. You have the examiner saying that these things are not patentable. I'm responding saying, yes, it is, and here's why. So it's a legal battle that goes on for probably about a year and a half. And then once it's issued, once you receive a notice of allowance and you pay the issue fee, then you get registration as a patent. And that's usually down the road. But patent pending is just a way of telling. Yeah, it's just a way of telling people that, hey, I've applied, I got my filing receipt, you can't use it. That's which is not true. They can still use it. They just can't get a patent on it. Yeah. And it's almost, think about patent pending is like escrow. It's like it's kind of yours, but it's not yours until it's closed. Take possession. Yeah, exactly.
It makes sense. So, Darryl, how do the audience reach you by phone and email?
Sure, they can reach me. My personal email is dscott@darrylscottlaw.com. The surname is DARRYLSCOTTLAW.com. Or they can go to ineedpatentprotection.com and they can visit my website. And my telephone number is 832-446-3337.
And you're a proud member of the University of Houston alumni.
Very proud.
And you got your degree there in engineering?
Yes.
Oh, wow.
So I received a degree in mechanical engineering with a minor in information technology.
Awesome.
So
knowing that you wanted to do patent work?
No, I did not.
Really?
No, I did not even want to be a lawyer.
Well, you've certainly educated us today. You're obviously doing some networking. How has the University of Houston Cougar connection been for you?
Oh, it's been wonderful. So let me just say this as a disclaimer. I was apprehensive about networking. I did not like network. I did not like networking groups because I felt that it didn't have any, wouldn't have helped me in my business. Right. But I acquiesced and I tried. And I will have to say that networking action has definitely paid off for me.
Great.
Without networking action, I probably wouldn't be where I'm at today.
That's awesome. That's great to hear. I appreciate that. I know Joyce is leading that group, and she loves her Cougar, so she likes to take care of y'all. Y'all like her little other boys, extension of her real family. So. Well, thank you for coming in today. It's really been very educational.
Thank you for having me.
Talk with you. Thank you.
Thank you.